Good evening, everyone. I am Advocate Vikas Garg, founder and CEO of lawupdates.in. I would like to welcome you all in today's session. Today, we have with us Advocate Neerja Sharma, who is practicing at Supreme Court of India. She has done her BCom LLB from Delhi University. She is a former legal assistant in UP-RERA. She is an impaneled amicus curiae in NCDRC. She is founder and CEO of Decode the Law. She will be taking today's session on the topic Revolution in Land Laws, Real Estate Regulations, and Development Act 2016. I have a small announcement for all the attendees that they can post their questions in the YouTube live chat, which will be taken up by the ma'am in the end of this session. Now, I would like to invite Advocate Neerja Sharma to start today's session. Over to you, ma'am. Ma'am, your mic is muted. Kindly unmute your mic. Yeah, ma'am.
Hi, thank you so much, Vikas. And I would like to say good evening to everybody who has given time to attend the today's webinar, and would like to welcome you all. And just wanted to tell you guys, do you want to know about what real estate law is? Do you want to know about how this land law, that is the Central Act, has created a revolution in the real estate sector? Do you want to work in a company, in a real estate company, and know what all things that you can do? Do you want to practice in litigation in RERA side, and you should, like, you want to know things which are related to it, and can get things in your favor in a way by following a sort of a protocol and a practice? Then this webinar is for you. So we all have heard some way or the other, be it in a newspaper, be it on a legal blog, RERA, RERA, RERA. We all have heard some way or the other, right? What exactly RERA is? What is the objective of getting this Real Estate Regulation and Development Act by the Act of Parliament? What is the need of passing such act? Do, as a career, like, does it have a sort of a career for a new professionals, like new fresh law graduates in a company, or a self practice, or being outsourced, worked by the companies? Or even though you want to teach like me, like what I am doing, do you have that interest in you? Then obviously this webinar is for you, because lot of details I have compiled in 1 hour session to discuss your queries also, and to discuss the whole of the law in this 1 hour session of today. So here I'm starting my session, helping you guys to know what Real Estate Regulation and Development Act is. RERA. RERA basically means Real Estate Regulation and Development Act. It came in 2016, and some of the sections have been enforced in 16, but whole of the act has enforced in 2017 itself. 1st of May 2017, the whole of the act have came into the picture. So what is the need? What is the objective and reasoning is required by the RERA, to establish this Real Estate Regulation Act? It's basically to protect the home buyers, that we call it allottees, that we call it the flat purchasers, as well as the boost investment in the real estate sector. Real estate sector earlier was sort of unorganized sector. There were no authority to regulate it. Like we have development authority, Delhi Development Authority, Maharashtra Development Authority, or Meerut Development Authority, etc., etc. Every state has its own development authority getting their land-related documents registered, but there was no regulatory authority to regulate the activities of the promoters, because from the past 10 years what practically is happening in this area, that lot of development were going on, and lot of what do you say, builders have established, and they have initiated certain projects and providing possessions on time. But just giving you an example what exactly I'm trying to say, let's say a is a person, and he has booked a flat in 2014 and he was supposed to get a possession in 2013. Till date he has not received the possession, so there is some lacuna from the side of the law to regulate it. So home buyers are so frustrated that where do we go? So before RERA, if any aggrieved want to file a complaint, they can file a complaint before National Commission, Dispute Redressal Commission, NCDRC. We call it in short, it's called NCDRC. So people used to file complaint before there and used to attain relief from there. Or if somebody is not satisfied with the order from the NCDRC, in the case of real estate itself, they approach to the Supreme Court. So this is how it works. But now that the RERA has came into picture, they have actually, expedited the sort of relief to be provided to the home buyers. How? I tell you, this act has a central act. It is a central act, but every state has its own regulation for the real estate sector, and have its own adjudicating body and authority for speedy dispute resolution mechanism. They also have it, which we call it the conciliation or the mediation. So most of the states have established two of the mechanism. One is the complaint side, and somebody who does not want to get into complaint, or file a complaint or getting the matter settled in a form of a speedy dispute redressal mechanism, that we call it conciliation or a mediation, they can do so. So this is one of the aspect that has reduced the burden of the normal court, and also expedited the result or the relief to be given to the home buyers, because home buyers are basically the most victimized in this area. First, second, that a regulatory part has came into picture. I tell you how. So just before proceeding further and telling you how this process is being done, this particular act is a very small act. It is having only 92 sections itself. So it surrounds with only 7 sort of stakeholders. That is, one of these home buyers, or we call it allottees, the promoters, the real estate agents, the adjudicating officer, the real estate regulatory authority, real estate appellate tribunal, and central advisory council. To cover all these aspects in this 1 hour is very difficult. So I will be covering the questions. That is, since I have been the legal assistant in UP-RERA, so many people I used to deal with every day. So whatever the questions that I used to receive at that point of time, I will be discussing those practical questions with you, instead of telling you about the law first. So obviously to understand the law is important. So simultaneously I'll be explaining you the questions, the practical questions that I have gone through when I was working with the UP-RERA itself, and people still have those queries, right? So first of all, RERA, when it came into establishment, it came on 10th of, the bill was passed on 10th of March 2016 in Rajya Sabha, and 15th March of 2016 in Lok Sabha. And on 1st of May, the whole of the act came into picture, 1st of May 2017, including the Jammu and Kashmir. Jammu and Kashmir and the Union Territory of Ladakh also having this RERA Act. That applicability came from 30th October 2019 when this notification came out, right? So this particular act is a central act and it is applicable to whole of the India, and every state has to has to creates its own authority, its own appellate tribunal, its own body, its own CAC. They have to create it at the state level itself. So I will tell you how this state level, it's called the they prepare it, and they have to, they are bound to create a body to protect the interest of the consumers, and how to regulate the promoter side. Promoter, we call it the real estate companies. Here the definition is being specifically provided. The promoter is for the real estate companies, or the person who is selling a plot or a flat or apartment, or home buyer is called an allottee, right? So what is the need and objective of enforcing this act? The first and the foremost need that I've already discussed with you is that this sector was unregulated for a quite a period of time, and the remedy which was supposed to get it from the side of the consumer forum itself, it was curative, we call it, it is remedial in nature, but there was not preventive. Like if we regulate it or at the very beginning, if we know it that what time we'll get the possession, let's say there is a project A, so the details of the project are already mentioned on RERA website, and we can always check what all the approvals are there, what all the layout plans are there, what, when are we supposed to receive the possession. Everything is available on the particular state RERA website, and this is called transparency, I'm so sorry, and this is called basically to regulate the promoter side. How many sections, chapters, rules, and regulations are divided in the act? It is basically 92 sections are there amongst the 10 chapters. So if anything needs to be amended, who will going to get done? This is basically, it is being done by the Ministry of Law and Justice. And every state has to make its own rules and regulations. Why? Because in order to execute the land laws, every state has its own local land laws. We call it for the recovery part, or we call it for the recovery of the revenue part. So that is how the every state has to collaborate it with the rules, with their local laws, so that there has to have no contradiction between the RERA Act as well as their local laws. So the governance of RERA. What is the governance of RERA? Who governs the RERA? Basically, it is all defined in the act. The act is so beautifully defined that we don't have to go here and there to check out. It is exactly like Companies Act, that everything is so much beautifully defined. Same is with RERA. So in this case, the governance of RERA is with the appropriate government. Here we call the appropriate government is the state government. It can be for the union territory, it can be a central government, and for the state, it's a state government. That is, for the Delhi, it's, we call it the union territory. So it will be governed by the central government and Central Ministry of Urban Development. And for the state like UP, like Maharashtra, they are governed by the state government itself. So now I will be discussing the questions that are, usually that are the most common questions being asked by the allottees who used to come before the RERA. And there are certain questions which are also related to promoter also. I'll be discussing that also. So yeah. What is the relief that is available to the home buyers and consumers or allottees? So basically, the central government has enacted this act. Then what is the use? So people are asking us What is the relief that is available to us? Do we get possession? Do we get refund? So basically, the relief that is available to the consumer or the home buyer is basically the amount they have deposited, the penalty amount, and the interest. So they get the amount that they have deposited as well as the interest and compensation. So whatever they demand from the authority, an authority thinks fit that the person is required to get the penalty amount and interest and compensation. So the authority provides that in the form of order. So basically, though it's a quasi judicial body, but it acts exactly like how the court functions. So yeah, so in the case of conciliation and mediation, negotiation takes place. Level of resolving disputes between the home buyers and allottees and promoters and cooperating housing society. Even the cooperating housing society can also, go before the court and ask the relief against the builder also. And thirdly, the even though I am a person who is not the allottee of let's say ABC project, just giving you an example, and then I'll come on to the conclusion. The point is that I came to know that the person is selling a project, right? Selling a flat in a particular project, and I know that the registration has not yet taken place. So the basic and the foremost condition in order from the side of the promoter to sell the project is to get themselves registered first. Once it is registered, then they can sell the project, then they can do whatever they want to. The registration number needs to be obtained from the RERA authority. That is mandate upon that. That is a regulation part again. So just in that context, if I came to know that a particular ABC project has started selling its flats and has taken the amount also, but has not taken the registration, I can go for the whistleblower policy. I can inform that particular state that see so and so project has not get themselves registered with you and they are selling the flat. In that circumstance, they have to pay a penalty to the authority, which is heck of amount of the project, like really heck of amount. So people who wants to work in the organization of real estate company, make sure that all the projects who are going to you are going to sell it, it needs to be registered. Mandatory, mandatory, mandatory. Then what are the consequences on the basis of which the promoter is liable for refund under the act? Now we say it, okay, I want refund. In what circumstances I can get a refund? Let's say I'm a lottee, I've purchased a flat. In what circumstances I can ask for the refund? The first and the foremost circumstance is that if a lottee wants to withdraw from the project, if he wishes to withdraw from the project, then he will be entitled to receive the interest and compensation. I will further explain what interest is, how much the interest is computed, how much it is calculated. I will explain it further. In the second circumstance, it could be that if a lottee wants to continue in the project, meaning thereby he does not want refund and he wants to take a possession of that particular flat, and because the possession is delayed, he can ask for every month interest till the handing over of the possession at a prescribed rate. So now I will explain this interest. Every state has defined in its rules because the act prescribe what is to be done. The rules and regulations prescribe how is to be done. What is a protocol to be followed? What is the process that is required to be followed? This prescribed rate, every state has a different. Let's take an example of Uttar Pradesh. They are giving the interest rate is marginal cost lending rate plus 1%. We call it MCLR plus 1%. Let's take an example of Haryana. They are charging MCLR plus 2%. that is marginal cost lending rate plus 2%. Let's take an example of Maharashtra. They are charging, they are providing relief with the interest amount, that is MCLR plus 2%. So every state has prescribed its own interest amount in their rules itself. So this is what my point is to explain it to you. Okay, what is the time period? Now this is a very important question that I have received so many times. Okay, I filed a case before the RERA. Ma'am, please tell me when we will get refund. We have filed this case. Please tell me what is the time period of receiving relief to the home buyers. Like, I'm a lottie. I have booked a flat. I have not received the possession. I needed refund. I have booked the complaint. Please tell me when will I get refund. The act mandates that the complaint should be disposed of within 2 months, that is 60 days. However, the RERA is unable to meet that timeline. So, in practicality, considering the 60 days period usually gets extended in the normal course of nature, it seems that the home buyer gets relief only on a bona fide grounds. Approximately, it the getting a time of relief is approximately 6 to 8 months. Why? Because on one date the application is filed, on another date the notice is on the very first date, on the date of first hearing, notice is issued. Notice, after that issuing of notice, the reply needs to be filed by the opposite party. After that reply is filed, the rejoinder is filed, and then the final arguments, and then thereafter the order comes. So this time period, in that in this given process, sometimes the court orders for the inquiry also, sometimes the court orders for the forensics also. So this time periods approximately take 6 to 8 months, which may be extended. So this is the basic nature to understand what is the time period of receiving the relief. So the time period of recovering money from the principal civil court. Now we have received the order. I have received the refund. The execution will take another time period. So that time period may vary according to the circumstances of that particular state as well as the local laws. So once the order has been received, once the recovery certificate has been received or the warrant certificate, this recovery certificate is basically the certificate on the basis of which the order has been passed by the RERA. The execution department issues the recovery certificate, and that certificate goes to the the principal civil court to execute and get the money from the builder. That money will be transferred to the RERA fund, and that money will be given to the particular allottee in that particular circumstance, right? Let's say an order is being passed, right? I am a lottie, an order has been passed, but I am not satisfied with the order. What can I do? What is the remedy available to me? The remedy that is available to me is that I can anytime go before the appellate court. The time period of going before the appellate court is 60 days. Within 60 days from the date of receiving the order, and in case that 60 days has been lapsed, we have to provide a sufficient reason that why I have not able to file my case within that time period. Usually, in practicality, the court listens to you and usually waive off the time period by accepting those reasonings by the allottee. Now, these were the questions which are related to the allottees. So I don't know, many of the students must be thinking of the madam is, kept on talking about allottees, allottees, allottees. Then what is the, area for the promoters? That is for the real estate company or for the promoter side or for the person who is selling a project. It can be a real estate agent also, right? So what type of project that are required to be registration? Not all projects require registration. Only certain type of projects required to be registered under the RERA Act. So I will be discussing it with you all. That is, first one is that new projects, that is the prior registration is mandatory to be done by the promoter even before advertising, even before marketing, even before booking and selling of any plot. So new projects, let's say if I am the promoter, I have just received, I'm a real estate builder and I want to construct a project and provide flats to the allottees. I need to first get myself registered with the RERA. This is the first circumstance in the present scenario. Second is the ongoing project. Basically, what does this ongoing project means? It means on the date of the commencement of this act, that is, we take the commencement part of 1st of May 2017. Why? Because the whole act came into enactment on that day very itself. So on that date, if the completion certificate is not been issued, this certificate, the completion certificate, is being provided by the competent authority. It can be a just giving you an example for just to make you understand. It could be a Noida authority or a Greater Noida authority, just for an example reference. So they provide the completion certificate. If that certificate is not issued, the project is considered as an ongoing project and required to be registered. Third and the foremost circumstance is that in case the project is beyond the planning area, that is the area that is going to be developed with the requisite permission, then in that circumstance, it's a discretion of the authority to get that project required to be registered under the RERA Act for the benefit of allottees, and they can direct the promoter to get themselves registered from the stage of registration itself, be it the project is under construction or has provided certain possession to the flats, or whatever may be the circumstance. They are required to be registered if the project is beyond that planning area. The planning area is the area which is going to be developed with the requisite permission from the competent authority. This planning area definition, every whatever word I'm using in this particular webinar of today, every word is defined in the act, right? So I just discussed with you all which are the projects that are required to be registered. Now there are certain projects that are exempted, that do not require any registration. Let us understand what are they. That are the projects that are beyond the planning area, that is the area of the land that is going to be developed does not exceed 500 square meters, or number of apartments does not exceed 8. That is, either the area should not be more than 500 square meters, or the apartment should not be more than 8, in all phases, including in all phases. This particular planning area can be reduced by any of the authority if they deem fit. That is again the discretion of the authority. Then second circumstance, if the promoter received the completion certificate, let us understand in that case, if the project is an ongoing project and completion certificate not issued, it is considered an ongoing project. Once the completion certificate is issued, it is considered a project which is exempted and does not require to be registered. Then the project, if any of the project which is completed and everything is sorted out, only if it is under renovation, a repair, or some redevelopment work going on, but no selling or no new allotments are going on, those projects are again exempted from registration. Then the real estate project developed in phases, every phase is required to be standalone registered. Every state has its own registration number, or every project, let's say there is one project A, and that A project is required to be registered under phase 1, and project A, phase 2. So both of the projects are required to be registered differently, separately. So this is from the promoter side questions that I still encounter sometimes. Another question: at what stage can a promoter start to advertise his project for sale? Obviously, when the project has been registered with the regulatory authority and have received the registration number. Why? Because once they do the advertisement, they have to put that registration number on that very advertisement page, so that everybody knows that this project is registered and everybody can check it on that particular state website, what is the registration and what is the layout plan, what is the approval they have received. Every details is being provided by the promoter. Now again, this is a question from the side of the promoter, that is a real estate company, is that what are the details that are required to be furnished at the time of completion for registration of real estate project with the regulatory authority, right? So what details that we need to provide? The details are basically, the basic and mandatory thing which is for all of the RERA is that they have to create an online portal. Why? Because to make the transparency. So every state having all of the promoters has to provide its all details on that particular RERA website. They have to provide the details on their website also, that is the promoter's website also, but the major details, everything details has to be provided in that state RERA website. So that needs to be, thoroughly examined, and every detail has to be properly given. That is a mandatory part. Why? Because we are providing certain information to the authority, and from there people are actually checking it, and from there people are actually coming and buying that particular project. So detail has to be authentic and has to be provided to the RERA. So how these details are provided? They are going to receive a login ID and password after applying it, and that login ID and password is for their future reference for uploading all the details regarding their project. That is the promoter. Every time I'm saying promoter, meaning thereby it's a real estate company, right? So, okay, now we have understood what details that are required to be provided. What are the formalities that, for the registration of a real estate project that we need to fulfill, right? The formalities is that we need to, first of all, by, filing an application online, we have to pay a fees, and we have to provide documents like their incorporation certificate or PAN or partner details, the details of project, their ITR of 3 years, sale deed, lease deed, layout plans, and any other additional documents. In how many days the regulatory authority required to register the real estate project? I am the promoter company. I have applied for the registration of my project, but I have not received my registration number yet. What is the remedy that is available to me? The days that has to be, the authority is required to register a project within 30 days of the application. So in case authority fails to take a decision within 30 days, the project shall deemed to be registered, and in that circumstance the any of the representative of the authority can go before the authority, representative of the promoter company, I'm so sorry, shall go before the authority and state that, see, 30 days have been passed, kindly provide me the registration number. So we have to, with all the documents that we have already provided with this application, the registration number is being received to that particular promoter. Just give me just give me 1 second, guys. Yeah. So sorry for this. So the project is required to be registered within 30 days time period, right? That is mandatory part. Then what is the validity of the registration granted by a authority in that particular real estate project? So our act, that is the Real Estate RERA Act, says that the validity of the registration granted to a project shall be the period declared by the promoter to complete, that he would able to complete the project. For instance, just giving an instance in respect of this, I have applied for the registration of a project on 1st of May 2020, and I will be completing and delivering all the completing all the flats of a project will be on let's say 1st of May 2023. So 1st of May 2023 is the validity of the registration. So it will be like that. So the time period that has been mentioned by the promoter is considered to be the validity period of that particular real estate project. On what basis is the promoter required to withdraw the money? Okay, now we have come to know how is this registration is going to be done, what is the relief available to the allottee. Now from the promoter's prospect, on what basis is the promoter required to withdraw money from the separate bank account? This is very, very important. Why? Because every promoter has to open a separate bank account for a particular real estate project. There are two of the states that I came to know, that is the Karnataka RERA and the UP-RERA, has basically obtained this separate bank account directions to obtain a particular sort of certificate from architect, that so and so project is has been completed, and also a certificate from the chartered accountant that this much percentage of project is completed, and on the basis of that percentage they can withdraw the money by showing it to the authority, because the money has been deposited in a separate bank account, but with the approval of the authority they can withdraw from that particular project. So this is how it goes. So is the application for registration of a real estate project proposed under the act is manual, or it can be done online? So earlier it was manual. Why? Because when the act came into force, there are a lot of RERAs which were under its implementation, but now all of the RERAs has came into its implementation, all of the state RERAs. The recent one which I just told you, it's Jammu and Kashmir, and one of this is Mizoram. They just came into in 2020 itself. Otherwise all of the state RERAs have came into its implementation since 2017 till 2019. So yeah, basically, because every state has to create its own authority within a period of 1 year, so they were accepting the applications basically manually also earlier, but now they just have to apply it online. Everything is online. They have to provide all the details online. They will be getting login ID and password online. So things are tech savvy, in particular this RERA aspect. So every registration has to be done online. Can the period of registration granted to a real estate project by a regulatory authority be extended? I have given it, just taking that again example, when my time period was going to be on 1st of May 2023, and let's take an example now that today is 1st of May 2023. Will I get the extension because I'm not able to complete the project? As per the act, there are two conditions, basically two situations that are mentioned, where I as a promoter can get a registration. That is, the extension of registration can be granted in case of force majeure circumstance. The best example is of this is the COVID one. Ministry of Housing and Urban has given the suo motu extension of 6 months, and then every state has given the extension of another 6 months. So this force majeure clause is understandable by all of us in the form of COVID situation that we have all been, we all have seen in this today's scenario. Then Then another force majeure clauses can be a case of war, a flood, a drought, a fire, cyclone, earthquake, or any other calamity caused by nature affecting the regular development of the real estate project. What are the next steps that can be taken from project completion in case of revocation of a project? Let's say my project, I have registered a project, but that project is being revoked. So in case a project is being revoked, that is the registration has been taken back by the authority, then in that circumstance, section 8 of the act provides that there are several mechanisms in which the project can be completed. How? In such a scenario, either the association of allottees shall have the they will be having the first right, either them or the development works or the authority do the auction and get the developer from the outside, or they complete the project. So it is basically totally the call of the allottees whether to they want to get the whole project complete themselves, or they want some other developer that needs to be basically appointed, or basically done the auction, so that somebody come before them and then they purchase it and then they try and complete the project on time. Can the promoter modify, amend the sanction plans or the project specifications? Let's take an example. In this scenario, I am the promoter. I have a layout plan to construct. Let's take an example of 10 flats, right? So if I am constructing 10 flats and I know that I'm not able to construct those 10 flats due to some some sort of glitch or some sort of approval that is not received from the not from the any of the authorities, so in that circumstance I have to take a permission from the 2/3 of the allottees. That is, if there are 10 flats, so out of those 10 flats I have to take the permission from the 2/3 of the allottees, so that I can amend that particular sanction plan that have already been approved by the particular authority. That is called the major modification. Any minor modification can be done by himself also, there is no problem in that. So interest, I have explained it to you, that will be the MCLR. On what basis the rate of interest is levied? See, whatever questions today I'm discussing it with you, right? These are the questions that are the real time practical questions asked by the general people to me till date also. So that is why I just wanted to apprise you what RERA is, what actually the revolution that has come into that land law in a form of regulation. So I think my purpose of getting this webinar arranged is to make all of you aware, who everybody who is watching my webinar of today, right? Now, who can pass the order of the compensation, right? The order of the compensation can be passed by the adjudicating officer. So there are two things now. One is the authority, and in the authority there is one adjudicating officer. So if I want only the refund and the delayed penalty or the interest, then I can go before the authority. Or if I want delayed penalty, interest, and mental harassment or litigation costs or default or anything which is related to compensation, I will be filing my application before the adjudicating officers, right? So for all of you guys, if you are students, or even if you are a professional, or even if you are a lottie, or somebody who is going to be in real estate companies, this particular sector in 5 years down the line is going to be a boon sector, right? In the form of regulation, in a form of litigation, and in the form of teaching also, and in the form of the any of the financial institutions, if you guys want to join. So what are the careers that are available to all of the young lawyers and the fresh graduates? Is basically they can be an in-house counsel. So the basic knowledge you should have it, and then the in-depth knowledge you also should have it in order to practice it properly. Because one glitch in that real estate company, highest the penalty that is required to be paid, right? Then second thing, the professional can practicing and compliancing and registration part. They can do the litigation also. Student can work in a corporate law firms. Any person who wants to be a real estate agent can also this will also help them. And second thing is about that in-house counsel of that government company, like NBCC is one of the government company who is constructing the flats in the real estate sector. Then NBFC, then also people can also aware other people about this real estate law, that how is this law is actually going to be a revolution and a boon in this today's scenario. So, if from this today's webinar, I just want to thank you all that you all have given time to me, and bear with me for this today's webinar. Just a short announcement for you all is that if any of you is interested in this real estate regulatory authority course, they can contact it to the law updates coordinator. He will provide you all the details in a day or two. The course basically includes what is the background of the law, and how is this connected with the civil court, and then what are the laws, that other laws that are linked with this act, what is the registration is required to be done. We need to cope up with it, all the judgments that we have already received till date. These judgments are not you know publicly available. Obviously, for every on every website it is available, but it is not usual course of nature. It is not available like other judgments too. So this course have provided the judgments also, and the rights and the obligations of the home buyers or the allottees, the rights and obligations of the promoters, and person who can file a complaint, what is the compensation that they can get, what is the process that they need to follow, how they can achieve the interim order, what is the perfect draft of the complaint that they have to use, what are the documents that they are required to show, everything that is available in that. Thirdly, one of the things that I have recently added is that I've just completed one of my course today itself, and my students are really happy. So my point is that I have recently added one of the thing is that Supreme Court has, Supreme Court has established its own practices and procedures, right? Because when the case goes before the Supreme Court, it is basically how the practice they follow. So I have, basically establishes the whole case study of one of the cases, which is of the Supreme Court. So for better understanding the, and that will help us in establishing the process that how we can also follow to get things expedite at our level even before going to the Supreme Court of India. So from this I end my session of today, and you guys can ask me any of the questions. I'll be happy to answer.
All the attendees can post their question in the YouTube live chat, which will be taken up by the ma'am now. So, ma'am, there are some of the questions which they have already asked. So, ma'am, the first question is why RERA is not applicable for all states of India?
RERA is applicable for all of the states of India. This is what I was trying to tell. Every see, there is a central act, and then central act there is a state rules and regulations. So it is applicable to whole of the India, and now after 30th October 2019, it has included even Jammu and Kashmir and Ladakh also. So it is applicable to whole of the India, and every state has its own process and procedures to follow in their own state. Because I just explained it to you, every state has its own local land law, so that has to be collaborated with the RERA. So that is how it is. Yeah.
Okay, ma'am. Ma'am, the second question is if Maharashtra Housing and Development Authority is constructing the project, Do they have to go through the RERA?
Yes. See, even any of the let's say this Maharashtra Developing Authority or Delhi Development Authority or the Noida Authority have initiated a project. They have to get themselves registered with the RERA. They also come into the same vicinity of that promoter also.
Okay, ma'am.
So yeah.
Ma'am, the next question is land purchase included in RERA or only home buying?
Come again.
Is the land purchase included in RERA or only the home buying is included? Like
You,
someone purchases a land, will it be included
Mhm.
in the RERA?
The plot, okay. Okay, I got it.
Yes, ma'am.
The question is basically the answer to this question is that the act includes the plot, the flat, the apartment, the tower, or the building. It includes all that.
Okay, ma'am.
Yes.
Ma'am, the next question is how the authority get appointed in states?
This is basically I need to give another webinar for that because that is basically I have to cover several things in that. I have already covered in my course also. Just to give you a brief view, it is basically by a committee that has been set up, and they have should have a relevant experience. And once they have gained that experience, the committee should have appointed them, and then their appointment takes place. It
Okay, ma'am.
requires a detailed webinar for that. For this today's 1 2 minutes line is not enough for that.
Okay, ma'am.
Yeah.
Ma'am, the next question is if the builder is not completing the project in time, can I
Yes.
claim compensation for the delay? If yes,
Yes.
what will be the procedure?
Okay. Now, there are two things. If builder has not completed the project on time, what is the relief that I want? The two types of relief that is being provided by the RERA. The first one is that I want to withdraw from the project. See, I'm so fed up from this particular, builder. He's not providing me the possession since 10 years. And now he's saying, okay, I will provide you possession after 1 year. I'm saying, no, I'm not interested at all. There are a lot of Supreme Court judgments in this respect. You cannot enforce any of the allottee to take the possession after breaching of the agreement. That is, a possession was to be given in 2010, and now he is saying in 2020 that I will be giving possession in 2021. This cannot be happened. This is the first scenario of the point. And second thing, okay, I'm satisfied with the builder. I know that the builder can give me the possession, but in that circumstance I can ask for the possession for the delayed penalty and interest till the possession that I'm going to get. So two scenarios: refund plus penalty interest. Second scenario, that is the possession plus interest till the possession that needs to be given to me.
Ma'am, the next question is self-development of the housing societies covered under RERA?
Example, self
Self-development of
development.
the housing societies are covered under RERA or not? Like a
Actually,
private individual is developing a society, for example.
see,
Will it be covered?
every person who is
Hmm.
selling a plot, flat, or land or apartment is covered under RERA. He can be any person. He can be a competent authority. That is, I just explained it to you, a development authority. He can be a real estate builder. He can be a cooperative housing society. He can be anybody. So they have taken everybody into same bottle, so that they can be regulated with one area itself.
So the next question is, ma'am, RERA is still patchy in many states. When will it be a foolproof in all the states?
Okay. There are certain states in which RERA has not properly came into its implementation. Every act has, it usually takes 5 to 7 years to its proper implementation. Just giving you the brief gray area of the RERA, there are a lot of powers that is required by the RERA itself, but still they don't have. Why? Because the RERA is still under implementation. Like Companies Act 2013, when it came, it took 5 to 7 years to get in itself in implementation. Also, with all of the removal of difficulty clause, amendment clause, lot of rules and regulation that used to come. Same applies to the RERA itself. It's a new act, and it will take another 5 to 7 years to get into itself into full form of implementation. So yeah,
So I guess,
in
ma'am, that's all.
yeah,
So with this, our question answer round comes to an end. I would like to thank Advocate Neerja Sharma for such an informative session and for sparing time out of her busy schedule for this session. I have a small announcement for all the attendees that the e-certificates will be available on our website on 6th of October. And if anybody wants to know more about the course, they can contact lawupdates.in. The email will be provided to you in the YouTube live chat. So, with this, we wrap up this session. Thank you for joining this session and stay safe. Thank you, ma'am.
thank you guys. Really enjoyed a lot.
Thank you.